El siguiente programa es una producción independiente. Las opiniones, comentarios y expresiones del mismo no representan necesariamente las políticas institucionales de Doral Voice ni de sus patrocinadores.
Hi, friends. This is Rubén Alcoba. I'm here with Doral Voice. This is the first time I'm going to do a program in English, which is my native language. Although I was born in Cuba, half Bolivian, it just so happens that English is the language I feel most comfortable with, the language where I became a lawyer. And today we're just going to do a nice little presentation with cryptocurrencies, NFTs, Bitcoin, a little bit like that, and how you get these things patented. That's what I'm trying to do here, and we're going to see how this works out. Okay, the main thing that I want to go over first is what's the importance of this? Well, nowadays, cryptocurrencies, NFTs, they're talk of the town. There's a lot of money to be made in them. If you know how to invest in them, you could also lose your wallet investing in them if you don't know what to do. So it's a dangerous way of investing. But for those who know, they've gotten very rich in it, but they've also become very poor. So some of it always has to do with luck and stuff like that. Today, what I want to do is, first of all, so a lot of people don't understand what an NFT is. An NFT signifies a non-fungible token. What that means is that it's a virtual method of trading something of value that doesn't have another equal currency. In other words, a Bitcoin, a cryptocurrency, all the currencies are standard. They all have the same value. One cryptocurrency, like Bitcoin, another Bitcoin would have the same value as well. An NFT doesn't have that. It doesn't have that value. It has, in other words, if I have an image of something on my NFT, it's going to have its own specific value compared to other NFTs out there. Can I get paid using NFTs? Absolutely, you can get paid. Are NFTs copyrighted? Well, maybe they could be copyrighted, but it all depends if the original work was based on the NFT, or because if the NFT represents an artwork for someone else, then that copyright would belong to the original author of that work. And although you would have a virtual coin using that NFT, that would have that work for you to enjoy, listen to music, listen to the presentation, listen to maybe go to a show, a boat, maybe get access to an event, or maybe buy property with that NFT. But the work of art that's represented by the image you would see, that would not belong to the owner of the NFT. That would belong to the original author of the work. And if you were to try to reproduce your NFT, you would probably get sued eventually, or the person. It all depends. You might get sued, or the miner who minted the NFT might get sued. It all depends what he sold to you. Often, miners or producers of the NFTs, they sell you on something that maybe the NFT doesn't represent. It would be very difficult for the miner to send you the copyright to the NFT unless the miner himself was the author of the artwork that would be reproduced in the NFT. All of you guys know about Bored Apes, all these NFTs that have made a lot of money. I mean, that one of these apes was sold for $70 million. So everybody's trying to cash in on and catch the wave with them. Can you do it? Absolutely, you could do them, but you got to have some kind of gimmick, some type of hook to them. And then of course, once you have the hook that you want to say, well, how do I protect that hook? Can I get a patent on it? And that's what our discussion is going to be today about. Our discussion today is how to patent maybe an application or a method of selling an NFT. That's what we're going to talk about today. And we're also going to be talking a little bit about copyrights. How can you protect the image of NFT if you're the original author? Well, if I was the original author of the NFT, what I would do is I would first of all register my own copyright to protect my rights, like we've discussed on previous programs. And I would have to do this within 3 months for me publishing whatever my work of art is. After I do that and I protect my copyright, my image, then I would start minting it on an NFT if I wanted to somehow make money on the work of art that I've created, or the musical score that I've created, or any derivation thereof. But a mistake for all this would be for me to try to enforce an NFT or a work of art that I put on an NFT and more than 3 months have gone by and I didn't protect any protection. The good thing about that is if I'm just protecting a work of art or a musical score, as long as I do it within 3 months of my first publication, I'm going to get statutory damages. I'm going to get attorney's fees. It all makes it worthwhile, because then it makes it a lot easier for me to find a lawyer that would help me represent me if someone decides that they want to, pretty much steal my artwork, my thoughts, my intellectual property. If I actually show that I have a protected piece and actually show that someone else has published that piece in order to make money with that piece, then what's going to happen is that I'm going to get paid. They're going to have to pay. They're not going to be able to bankrupt it, because you can't bankrupt a copyright claim. It's based on the Constitution. And they're also going to pay my lawyers. So that's the beauty about the copyright law. As far as cryptocurrencies, the way you would protect cryptocurrencies would be based on maybe algorithms, method patents. You also have decentralized finance. You protect maybe the algorithm and a method of using that algorithm. In other words, and then we're going to cover all this and how to get an application or a blockchain or maybe even an NFT patented. We're always going to have to do it. We're always going to want to have to do it using a method type of patent, and that's the way we're going to go about it. I'm having a little bit of a technical issue, so what I'm going to do is I'm going to take a 2-minute break here, and I'm going to be right back here in a second. I just got to plug this computer, because it's going to be hard for me to do this presentation if this computer goes off on me. This is Rubén Alcoba. Give me 2 minutes. I'll be back to continue how we can get a patent on an NFT, an application, a cryptocurrency. Thank you. Ya.
Si hay algo que nos caracteriza en Doral es la buena comida y los grandes eventos. Por eso, impacta tus invitados con Brunellas Cater, donde encontrarás un menú variado y a muy buen precio. No te vas a equivocar. Llama a Brunellas Cater al 786-329-2993 o búscalos en Instagram bajo Brunellas Catering. Déjales dicho que te recomendaron. El venezolano News, decano del periodismo de primera por más de 30 años en el sur de la Florida. Búscalo semanalmente en múltiples puntos del Doral o visítalos en su página web, elvenezolanonews.com. En estos tiempos difíciles, una celebración puede ser bien costosa. Eternity te puede ayudar a preparar fiestas con excelencia y calidad. Llámate a Valentín 786-991-3967 o búscalos en las redes sociales bajo Eternity para que puedas ver la calidad del evento que Eternity Si quieres almorzar sabroso económicamente en la 79 Avenida de la 46 calle Northwest, restaurante Eurocafé Express, sándwiches, almuerzos ejecutivos de primera calidad, con buenos vinos y una atención de primera. Visita nuestro centro. Para más información llama al 786-362-2471. Restaurante Eurocafé Express.
Friends, thanks again. I'm over here at Doral Voice. We're going to continue the presentation. As you are already aware, my name is Rubén Alcoba, and today we're going to be doing a presentation that has to do with how to protect cryptocurrency and how to get a method patent on an application or a cryptocurrency. I told you a little bit about NFTs in the prior section, and as far as DeFi and stuff like that, there's a lot of books on it. There's no reason for me to bore you with it, and it's super complicated. So let's just get to the point what this today's information is going to be about, which is the patents. We're going to call it a manner of protecting your method, blockchain, or application. That's going to be the presentation. And Julio, let's go to the first slide so I can pretty much start this off. Okay, so what type of property will an application an NFT, what are we looking at? We're either going to be looking at a copyright. Is it a work of an original work of authorship? If it is, and it's on a medium, that would be a digital medium. Is it fixed on an NFT? An NFT would fix on some type of digital medium, so that could be considered a copyright. What right does a copyright give you? Well, it gives you the right to exclusive right to reproduce, distribute, perform, display, prepare derivatives of, and digitally transmit the work. It may also work with copyrights notice. Okay, what's a patent? Well, a patent it allows an inventor to protect a new machine, process, or article or manufacture or improvement thereof. What right does a patent give you? Well, it gives you the right to exclude others from the United States from making, using, selling, offering for sale, importing, and in some cases exporting implementations of their claimed invention. And then lastly, what's a trademark? Well, trademarks would be the name of the cryptocurrency. Bored Apes would be a trademark, that would represent a type of NFTs to come from that group. In other words, the trademark is going to tell you the source of products and stuff like that, and who owns it in case you have to go after them, or in case you just want to make sure that you're buying the right product. Julio, let's go to the next screen, please. Okay, so what's a patent? Section 101 of the United States Code says a patent is whoever invents or discovers any new and useful process, machine, manufacture, composition of matter, or any new and useful improvement thereof may obtain a patent therefor, subject to the conditions and requirements of this title. Okay, what that means, this is what's patentable. So processes or methods are patentable, machines are patentable, articles of manufacture are patentable, compositions of matter are patentable, and improvements thereof are patentable. When we're talking about cryptocurrencies, NFTs, we're going to be trying to protect them using process patents. In other words, methods of using an algorithm, a method of using some type of application. And if we could give it some practical applicability, then you're going to get a patent. If you can't do that, if it's just an algorithm, you cannot get a patent. Let's go to the next screen, please. Okay, 4 things are required that must be met to get a patent. A patent means only one patent granted to each invention, and that means there could only be one inventor for an invention. If the thing already exists, then you cannot be the inventor, for that means that an inventor had previously made the invention. Useful, well, that's got to have some type of use. It must have a specific, substantial, and credible use. What that means is, okay, it just can't be I have a rock and I'm going to move the rock over there. No, I got to say I have a rock, I'm going to move the rock over here, and when I move that rock over here, it's going to generate some energy. That would be the use. It's got to be either a process. A process is a method. It's a way of getting from A to B, and there's going to be exclusions to it. A machine has different parts. An article of manufacture would be just some type of mold, but that mold, when I have that mold composed together, you would be able to do something with it because it would have to have a use. Or a composition of matter, which would be a chemical formula. And whoever invents or discovers, that means you have to be the first person who invents or discovers the invention. You cannot discover things that are already in nature or compositions that are already in nature. You have to somehow be able to compose them and put them together and come up with some new composition. Let's go to the next screen, please. Okay. 4 categories of statutory subject matter that can be patented. A process, well, again, an act, a series of acts or steps. Actually, that's the way they like to define them. It's a series or acts or steps that come up that give you something that's useful that was not out there before you came out the way of making this method. A machine, a concrete thing consisting of parts, certain devices, combination of devices. Article of manufacture is an article produced from a raw or prepared material, but give these materials a new form, quality, property, combinations, whether by hand, labor, or machinery. And compositions of matters, all compositions of 2 or more substances, and all composite articles, whether they be results of chemical union, or a mechanical mixture, or whether it be gases, fluids, powders, solids, for example. But again, this presentation, we're going to concentrate on an act or series of acts or steps and a process, and that's what we're going to be concentrating, because that's the way applications, that is the way cryptocurrencies, That would be the way NFTs would be patented. If I could give them some type of certain use that would have a practical application for them. Let's go to the next screen, please. Okay, so the courts have interpreted the statutory categories to exclude. Okay, so in other words, we know what's patentable, but the courts say, okay, although this is patentable, there's things that, although you could read to them for them to be patentable, they wouldn't be patentable because of exclusions. So what are the three exclusions? Laws of nature, natural phenomena, and abstract ideas. Laws of nature, natural phenomena, and abstract ideas. These three terms are typically used by the courts to cover the basic tools of scientific and technological works, such as scientific principles, natural occurring phenomena, mental processes, and mathematical algorithms. Mathematical algorithms. I want you to keep that in mind. But those are the judicial exceptions. Mathematical algorithms, if we really think about it, that is really much what most of the applications that you use on the internet or on computers or your tablets or your phones, they're all going to be based on some type of mathematical algorithm. And although they're called exclusions, there's ways to get patents using exclusions, and we're going to go with that in the next slide. Julio, please. Okay, so abstract ideas, judicial exemptions. A mathematical concept. Mathematical relationships, mathematical formulas or equations, and mathematical calculations. Okay, cryptocurrency patents, patents that have to do with decentralized finance, patents that have to do with security, they're going to be usually using mathematical formulas or equations. They'll use sometimes mathematical calculations, but usually what we're going to be using is some type of mathematical formula equation that's going to transform a certain word or number or symbol or code into, and it's gonna hide it. It's gonna try to switch it into a different type of language because you're trying to hide it. You can't, if you wouldn't hide it, then it wouldn't be you wouldn't be using cryptography. Then mental processes you can't get patented. For example, concepts performed in a human mind, including an observation, evaluation, judgment, opinion. For sure, this would not be patentable. And I'm not even sure if I could ever go around this with an application. That is why there's one way to get an application done, and we fall under a mathematical concept. But then I would have to also put other steps in that claim that would give me the patent using the mathematical concept. I would not be able to do that with the mental process. And the last thing that's a judicial exception is certain methods of over-organizing human activity. Fundamental economic principles or practices, including hedging, insurance, mitigation, risk. Now, I could maybe put that in as part of my claim when I get a patent, but then I would have to have other steps that would allow me to go around it, but more likely it would be very difficult. Commercial legal interactions, including agreements in the form of contracts, legal obligations, advertising, marketing, sales activities or behaviors, business relationships. Okay, when you talk about NFTs, really what you're doing is talking about contracts. When you're talking about crypto, well, where the backbone to the blockchain are contracts. So that's the way you're going to get paid with them. You're going to be closing contracts, and that's the way people will mine their coins, or they used to mine their coins. Now there's going to be different ways of mining coins. Now you can mine for them, and I think you could also buy an equity interest in them. And but that's a different subject. And then you have another method of organizing human activity, managing personal behavior or relationships or interactions between people, including social activities, teaching, and following rules of instruction. What's the importance of seeing this abstract ideas? Whenever you're going to see it, if I have something to patent, I want to express the method of me doing something. And if when I write this patent, and if my method either includes a mathematical concept, a mental process, or a certain method of organizing human activity, I already know that that's a judicial exception. But even though it's a judicial exception to a patent, if I can somehow make that one of the elements of my patent, and I can give you a practical applicability, then I will be able to get a patent. In other words, okay, although these are exceptions, this just tells you, hey, right now, as it stands, this is not patentable unless somehow I can use this judicial exemption with other elements that would give me a practical applicability of the whole claim in the patent. Then I might be able to give a patent and then protect the method of use, even though it's got a judicial exemption. If we go to the next screen, please. What is a process patent? Well, a process patent is also called a method patent. A process pattern is the manner in which an inventor uses a set of steps to obtain a given result. A process defines actions. An invention that is claimed as an act or step or a series of acts or steps, as explained in the Supreme Court. A process is a mode of treatment of certain materials to produce a given result. It is an act or a series of acts performed upon subject matter to be transformed and reduced to a different state of thing. The term process requires action. A process already requires a series of acts. Okay, now remember when I was talking to you about the algorithm? Well, the algorithm, that would be one of the steps. If the algorithm in one of those steps, if I didn't have anything else, only that algorithm, that would not be patentable because that's a judicial exception to the patent. But if I had 4 steps and 3 of the steps were a way of using that algorithm, then I might be able to get a patent so long as the other steps would help me be able to define actions that would lead to give a given result that was not already out there, that would be a benefit, that would give some type of practical applicability to the system, the computer, to a treatment method, to something. I would have to be giving some type of practical applicability to my method that wasn't out there, that's not just based on an abstract idea. In other words, I need a little more than the abstract idea. Next slide, please. Okay. Can we go back 1 second? Okay, let's go forward. Okay, cryptic patents can be either process or method patents. They're actually the same thing. Cryptic patents, no, wait, go back, please.
No, this is the same one.
Oh,
Wait.
no.
No, yeah, you're right.
Crypto patents will always have a preamble. What that means is I have to have an introduction. This is a method for increasing security in a transaction between 2 different nodes, 2 different computers, and the method's going to comprise of, right there, I've just given you a preamble of what it is. In other words, I have to tell the audience what my method is and what I'm trying to accomplish, right? And then I'm going to go through the steps. So I have to introduce what I am trying to do. That's the preamble. And really, all it does is just gives you a title of what you're doing, so the reader knows where you're going to go from here. Let's see. Method, for example, a method for establishing cryptographic communications between a first computer terminal and a second computer terminal comprising. Okay, so in other words, cryptographic is the way that you would be encoding stuff so other third parties wouldn't be able to see it. It's hiding a code. After the introduction of the preamble, the steps of the process will be recited to obtain a certain result. In other words, I've already introduced what we're going to do, and now I'm going to tell you how we're going to reach the results. Those are the steps, and really that's the meat and bones of a process or method patent. It's the steps. I've given you what I'm doing, what the steps are going to lead to, but really what's patentable is the steps there. And when I do the steps, I have to be sure that if I have anything that would be an exclusion to a patent, I have to make sure, okay, if this is an exclusion to one step is an exclusive patent, then I have to make sure that the other steps give it some other practical applicability, or did that same step give it practical applicability? If it did, then I would be able to get a patent. Next screen, please. This is a sample patent that's used by the United States Patent and Trademark Office to teach how to analyze a claim. In other words, okay, here first thing is we have a method of establishing cryptographic communication between the first computer terminal and the second computer terminal comprising. That's the preamble. That's what we're doing. Then the first step is going to be receiving a plain text word signal at a first computer terminal. The second step, okay, now receiving a plain text word signal at first computer terminal, if you noted, that is not one of the abstract ideas. That is not a mathematical computation. That's not a way of organizing people together, and it's just not. So that step is good. Right now, I know that step is not an exception, so I'm already in good shape. Then it's just transforming the plain text word signal to one or more message block word signals. Okay, again, that's another step, and I'm transforming one signal to another. That's not a mathematical computation, and it's also not one of the 3 exclusions that I recited before. Now look at this one, encoding each of the message block word signals to produce a ciphertext word signal whereby CA equals MAE mod N, where CA is number representative of encoded form of message word, and where MA corresponds to a number representative of message in MA, which 0 is less than or equal to MA, which is MA is less than or equal to N minus 1, where N is a composite number of form. Obviously, that's a mathematical computation. Right there, I have an exclusion. And when I look at that step by itself, I notice that that exclusion does not give that step a practical applicability. That would be excluded from getting a patent if that's all I had. But luckily, I have the receiving, the transforming, and then lastly, I have a transmitting the ciphertext word signal CA to the second computer terminal or a communication channel. Okay, so right there, even though I had matter that would exclude the invention from being patented, the encoding step, I have the receiving, the transforming, and the transmitting step that were not previously found, that was not invented by someone else, that allows me to get a patent using an algorithm, even though it's an excluded from patent subject matter, because of the other three steps were not excluded, and then the method gave me something that was new, that was not out there. So the patent office says, okay, if you write a patent in this manner, and you could get practical applicability to an abstract idea, we will grant you a patent. And the abstract idea in this case would be the mathematical computation. So that's the way you get a patent with this type of invention. Now, what's important here is when you look at this claim, if you notice one thing, it always says receiving, transforming, encoding, transmitting. If you notice another thing is, when they write this patent, it's always from one person is doing this. I'm not saying it's always I'm the center, I'm doing this. I can't have three different persons doing this. So if I'm receiving, I'm transforming, I'm encoding, I'm transmitting, I can get a patent. Another thing a lot of people don't know is if you want to get a patent based on something like this, and I believe that with this type of patents, they have to be all done within the United States, within the territory where it covers. I can't be doing it in different areas of the world for whatever reason. It's just the way the code is made, and I have to be taking all steps. In other words, I would be receiving a text from someone. I would be transforming that text I received. Then I would be encoding that text, and then I would be transmitting that text to someone else. If you notice, I never counted on someone else to give me something because I've already asked for the information, and now I'm using that information. If we can go to the next slide, please. Okay, so then once I've already examined it for you, but let's see what the patent office says. When you get a claim, when you write a claim, when you're trying to write a claim, you want to examine it to a claim to see if it's patentable. Number one, does the claim fall under a patentable subject matter? The used PTO sample claim recites steps, so it's a process. Therefore, it is patentable subject matter. 2, does the claim have any judicial exemption? That claim had a mathematical formula, an abstract idea, so we have to look further to see if the claim has integrated the abstract idea into a practical application. If so, then the claim is allowable. If the claim is not integrated into a practical application, then we have to look further to see if a claim is allowable. Okay, so that's kind of interesting. So what that means is does the step that has the judicial exception, does it have the practical the application within that step? If not, then you have to look at the rest of the steps to see if the other steps are also judicial exceptions. If they're not judicial exceptions, then you would be able to get patent. Number 3, we have to see the claim to see if there is any additional elements in the claim beyond the judicial exemptions. Those are the steps. What are the other steps during the claim? And 4, we then have to evaluate the additional elements to determine whether they integrate the exception into a practical application of the exception. And the previous claim that we looked at, they did integrate the exception into a practical application because if we could go back, Julio, 1 second. If you notice, we received a plain text word signal at the first computer terminal. Then we transformed that plain text word signal to one or more message block word signals. Then we used the judicial exemption, and then we transmitted the ciphertext that was used to produce the ciphertext word in the encoding section to a second computer terminal over a communication channel. So the receiving, transforming, and transmitting steps were sufficient in to make the encoding step patentable subject matter, even though it was a judicial exception. Julio, if we can go forward, please. One more slide. Okay, so now what is integration into a practical application? Okay, what the patent office says is it requires an additional element or a combination of an additional element in a claim to apply, rely on, or use the judicial exception in a manner that imposes a meaningful limit on the judicial exception, such that the claim is more than a drafting effort designed to monopolize on the exception. In other words, you got to have some type of use, some type of benefit that you're coming here, not just use a mathematical algorithm, but really you're not doing anything new. It's got to be something that has a benefit. And who determines a meaningful limit? Let's see. In this case, it's the Supreme Court gives you the guidance. Our job is to write the meaningful limit in the claims and support it in written description of the application. What this means is when you write a patent application, although the claims are your means and bounds of your patent, of your claim, what you have to have make sure that all those steps are very well explained in the patent itself, in the description itself, and each step you have to give what the importance of that step is. If you can say, hey, this step improves the way of doing something by a certain percentage, then you want to put that there. If you know one of the steps really doesn't add anything to the game, then you have to have the step in the written description of the application, but there's not really a lot to say about it. But whatever is new, you want to make sure that in your description of your patent application in the background, you want to expound on it. You want to make sure you drill into the Supreme Court or whoever the judge is, whoever's going to read this, or to the jury, that before you came up with this step, this abstract idea, this algorithm wouldn't have done nothing. But because you're using this algorithm with this step, you're providing a benefit. And the benefit makes this computer much faster, it makes encryption much easier, it makes it much harder to decrypt something, it makes it the security much stronger by a certain fold. That has to be written in the description of that patent, because the claims are supported with what you write. So you want to make sure that the step has a meaningful limit in the claim and supports it in the written description of the application. The next slide, please. What is indicative of integration into a practical application? 1. Improving the functioning of a computer or to any other technology of the technical field. Did that abstract idea used with my step, did it improve the functioning of a computer or to any other technology or technical field? If it did, and I was able to describe sufficiently in the description of the patent, then it would give me a patent. And number 2, applying the judicial exception with or by use of to a particular machine. In other words, again, that would be a computer, and then I have to show by you using this abstract idea, I made the machine function so much better. But I would have to make sure that I have to incorporate that mathematical algorithm or the mathematical formula into with another group of steps in order to be able to overcome the exception. Number 3, effecting a transformation or a reduction of a particular article to a different state or thing. That means that could be an NFT, I guess. I mean, if I had some type of judicial exception, I say, okay, I'm going to print this thing here, and if you could figure out and somehow I'm going to transform this coin maybe into a boat somehow, then I might be able to get a patent on it. Of course, I would have to put different steps in it, and I think I could probably get a patent on an NFT that would award something to someone based on the steps that would come up with. I would have to think about it, because then I would be inventing an invention in front of you. But that's the way I would do it. Number 4, applying or using the judicial exception in some other meaningful way beyond generally linking the use to a particular technological environment. In other words, it's got to be more in a book. If it's got to be more in a formula, and yeah, somehow this formula is going to save the world, but I really don't know how to do it yet. I have to tell them how I got to show them how to do it. Julio, the next slide, please. Okay, well, we got to the conclusion here. I know this wasn't the most exciting class for you guys, but maybe it was. I mean, if you're trying to do crypto patents, and of course it would be exciting. If you wanted to do about NFTs, how they function, then it would be exciting. If you're interested in knowing more about this, I mean, this is the way of the future. You definitely should be, and you definitely, if you have methods that you think you could use an NFT to give an improvement to this world or to award a prize that's not already out there, arguably, if we follow the instructions that I've laid out in this program, then you would be able to get a patent. But again, it would have to be backed up by the description of the application, and it would have to be more than the mathematical algorithm. It would have to be more than the abstract idea. Listen, I thank you very much for having the patience to stay with us during this presentation. I apologize that I had to be looking up because normally I would have looked at the camera, but for obvious reasons, my computer went down, and like they say, once you're in the water, you might as well just swim to the other side or sink. So we swam to the other side. I hope I gave you valuable knowledge. Next time, we're going to try to get maybe some calls to come in. If you have questions about this next time I speak, please call. We're going to give you a phone number to call in. Call in. I'll be glad to answer your questions if I can. Otherwise, I will do it in the next show. Again, thanks to the Doral Voice, Julio, the Escobar family, and Doral Voice. I'm able to present this material to you. I hope it's of value to you. It's the first course that I've done in English. I might do more courses in English. As you can see, I can express myself a little better in English. And again, I apologize for having to look upwards, but my presentation was above me, so I had no option. And I'm here to help you. Rubén Alcoba, Doral Voice, Alcoba Law Group. If you have any questions you want to speak to me, contact Doral Voice. If you have questions you want to answer, contact Doral Voice. They will get the questions to me. I will answer your questions. I hope to see you next week, and thank you for listening.